In Arizona, real estate transactions, third-party affiliates, such as title and escrow companies, play a crucial role in ensuring neutrality, compliance, and secure handling of funds and documents. Understanding their legal duties, limitations, and the various ways property can be held under Arizona law is essential for licensees to act competently and protect clients' interests. Escrow Officer Performing Real Estate License Duties, ARS, Sheriff 32 2121A16. Under ARS, Pub 32 2121 or A16, escrow officers are exempt from real estate licensure requirements when performing their normal escrow duties. However, they may not perform activities that require a real estate license, such as negotiating sales or preparing contracts, beyond escrow instructions. Their role is to act as an independent third party who holds earnest money deposits and documents until all contractual obligations are met. If an escrow officer exceeds their authority, such as advising on contract terms or marketing properties, they may be deemed to be engaging in unlicensed real estate activity, which is prohibited. Escrow neutrality: escrow companies must remain neutral fiduciaries, serving both buyer and seller impartially. Their role is to follow the instructions of all parties and disperse funds or record documents only when contractual conditions are satisfied. Under ARS, Paragraph 6, R840, escrow agents are required to disclose any conflict of interest that could affect their impartiality. For example, if an escrow company is affiliated with a lender, builder, or brokerage involved in the transaction, this relationship must be disclosed in writing. This transparency prevents bias and protects the integrity of the closing process. Under ARS, PBR 6, 836, escrow officers and agents are prohibited from receiving compensation, kickbacks, or referral fees for steering business to or from any specific party, such as real estate agents, mortgage brokers, or title insurers. Accepting such compensation constitutes a violation of fiduciary duty and can result in license revocation, fines, or civil liability. Ways to hold ownership in Arizona. Arizona law recognizes several distinct forms of real estate ownership, each with unique legal and tax implications. Sole and separate property. ARS, Paragraph 25 213. Under AR Rules, February 25, 9213, property acquired by one spouse before marriage or during marriage by gift or inheritance is considered sole and separate property. The owning spouse retains full control and responsibility for the property. If that spouse later sells or encumbers the property, the non-owning spouse must sign a disclaimer deed to confirm no community interest. Community property, ARS, Sheriff 25 211 and 25 214 Arizona is a community property state, meaning that property acquired by either spouse during marriage is jointly owned by both, regardless of whose name appears on the title. Under ARS, Paragraph 25 211, all earnings and assets gained during marriage belong equally to both spouses. ARS, Paragraph 25 214, requires both spouses to join in executing deeds, mortgages, or other documents that convey or encumber community property. This ensures equal ownership rights and prevents one spouse from unilaterally transferring or selling shared assets. Community property with right of survivorship, ARS, Paragraph 33431C. This form of ownership combines the benefits of community property with the automatic transfer of ownership upon death. When one spouse dies, the surviving spouse automatically inherits the deceased spouse's interest without the need for probate. It also preserves the step-up in tax basis benefits available under community property. Joint tenancy, ARS, Paragraph 33431. Joint tenancy occurs when two or more individuals hold equal ownership interests in property with the same title and right of possession. Each tenant has an undivided share and equal right to occupy the entire property. Under ARS, P. 33 431B, if the deed includes the phrase With right of survivorship, the surviving joint tenant automatically inherits the deceased's share. Without this clause, the deceased's share passes through their estate or will. Tenancy in common, ARS, Parb 33431. In a tenancy in common, two or more parties hold ownership interests that may be unequal and transferable independently. Each tenant can sell, mortgage, or will their share without the consent of the others. Upon death, the decedent's interest passes to their heirs or estate rather than to the surviving co-owners. This is the default form of co-ownership in Arizona, unless another form is specified in the deed. Death of an owner, intestate estate, ARS. Paragraph 14-21001. If a property owner dies without a will, their estate is considered intestate and distributed according to ARS. Circar 14-2101. Part of Arizona's intestate succession laws. The statute establishes the order of inheritance. The surviving spouse inherits the entire estate if no descendants exist. If the deceased has children from another relationship, the estate is divided between the spouse and those children. If there is no spouse, the estate passes to descendants, then to parents, siblings, or other relatives by blood. In real estate transactions, this often requires probate before the property can be transferred, unless ownership includes a right of survivorship or was held in trust. Licensees should verify ownership status before listing or transferring property to ensure legal conveyance authority. Together, these laws ensure transparency, fairness, and proper transfer of title in Arizona real estate transactions, emphasizing escrow neutrality, lawful ownership structures, and clear procedures for inheritance and transfer upon death.